Good morning. Thank you for joining the Finance Committee. Today is Friday, March 29th, and this is a voting session. We have 4 pages of bills. We're going to get through as many as we can this morning. So we're going to start with David and House Bill 253.
Okay, House Bill 253 was heard yesterday, or not heard, it was held from yesterday. And for folks to go over the bill a little more closely, if you recall, it's an emergency bill from the Cannabis Administration to fix things that came up over the course of since legalization regarding the law governing the retail sale of cannabis in Maryland. So most of the bill deals with fixing those issues or addressing issues that have come up since then, like licensing nurseries. It also extends for 1 year the ability for folks to deliver medical cannabis, and another year for the folks to get to a certain canopy level who are growers, who are existing licensees. There was an amendment which you should have. I didn't do the whole reprint again, which conform regarding background checks. It just conforms to how this practice is currently being done, and this was submitted by the Cannabis Administration.
Do I have any questions? We'd like to move the amendment.
Yes.
Senator Giles has moved the amendment. Do I have a second?
Second.
Senator Klausmeyer seconds. All in favor of the amendment to House Bill 253? Come on, wake up. Okay, it's a unanimous vote on the amendment. Now, can I have a motion to move the amended bill?
Move favorable.
Second for House Bill 253? Do I have a second? Thank you, Senator Kramer. All in favor of the amended bill 253? Unanimous vote. Thank you.
Okay, the next bill on your list is was held from yesterday again. It's House Bill 465. This is the bill that initially would assess criminal penalties for violation of the employee misclassification law and the prevailing wage law. You have a reprint in front of you. It's been altered. The criminal penalties are gone, and this is the House bill, so it's amended. You amend the reprint amends the House bill to also increase the penalty for civil penalty for multiple violations to $30,000, which is what was done in the Senate bill. But in a difference with the Senate bill that went across, all the referral language is maintained in the bill as introduced.
Question? Thank you, Madam Chair. So when you say we have the reprint, is that the one we received last night, or was there a new one this morning?
It should be the same one.
Okay, so nothing changed.
Nothing changed. Nothing changed since yesterday.
Okay, perfect. And all the referrals are still in?
All the entities if there's a violation of tax general article, are still in the bill.
Good. Move favorable, Madam Chair.
Thank you, Senator Kramer, and Senator Giles seconded. All in favor of House Bill 465? I think we probably need to call the roll. What do you think?
Yes, I think.
Okay, let's call the roll.
It's favorable with amendments.
House Bill 465, favorable with amendment. Vice Chair Klausmeyer.
Yes.
Yes. Senator Kramer.
Yes.
Yes. Senator Hayes.
Yeah.
Yes. Senator Ellis.
Yes.
Yes. Senator Mount.
No.
No. Senator Guile.
Yes.
Yes. Senator Lamb.
Yes.
Yes. Senator Hershey.
No.
No. Madam Chair.
Yes.
Yes.
Okay,
Wait a minute. The vote was
7-2.
7-2. Thank you. Okay.
okay, the next bill on your list, this was heard this past week. It's House Bill 1116 as amended, and you have a reprint in front of you, so if there's a motion, it'll be favorable with amendments. It alters the exemption for a licensed restaurant from the requirement to obtain a trader's license by providing that the restaurant generates 10% or less of its annual sales from non-food items. If you remember the testimony, this is designed to apply to big box stores who have restaurants. And some of them, I guess, could conceivably just get a restaurant license instead of a much more expensive trader's license. And this would provide that they would still have to get those trader's licenses.
Thank you, Madam Chair. And quickly at the hearing, they talked about the amendment, and the amendment sort of broke out the size. but we didn't get into the specifics. Can you explain what that amendment does and what the specifics are?
The,
What's covered and what is not?
if you see the reprint, you go to the page 2 of the reprint. As originally drafted, it just said business, and it replaces business with restaurant licensed under subtitle 6. So you know exactly who you're talking about here regarding the, who this exemption is going to apply to. So, it's more specific. It just says restaurant rather than just the general business, which was meant to be a restaurant. So it puts the law back into what it originally was. As drafted, they struck restaurant and said any business.
Mhm.
And the bill was designed to get at these restaurants that are located within big box stores. So it just restores restaurant to the original restaurant. The exemption would apply to restaurants only.
Which restaurants would not be required to buy a trader's license?
Any restaurant that's not, generally, any restaurant is exempted unless they have, the idea is unless they happen to be located in one of these big box stores. So no restaurant has to get a trader's license unless they happen to meet these criteria, which means it's designed to get at these restaurants that are located in big box stores. So,
David, if I can add, a restaurant like Cracker Barrel, who sells a lot of retail,
yeah,
could end up needing a trader's license. So what it is restaurants that sell retail.
Right.
And if they sell more than 10% of their receipts in retail items, then they need a trader's license and the restaurant license.
Thank you.
You're welcome. Senator Reedy.
Thank you. Just where did the 10% come from?
I guess that was that came from, I believe, the Restaurant Association. They worked on these amendments with the sponsor.
Okay. Yeah, I don't know. 10% seems kind of low, to be honest. I mean, you got like novelty restaurants that will they might sell. If it was, I know we don't want it to be like 40%, but I don't know. It just seemed like 10% seemed kind of low to me.
Well, until this, they were required to have both licenses.
Oh, so this is allowing them.
This is helpful.
Okay. All right. Thank you.
Can I have a motion for
Move favorable.
on the amended bill 1116? We have a favorable. We have a second. Senator Kramer seconded. All in favor of the amended bill 1116? Okay, unanimous. Thank you.
Okay. Okay, the next bill is a local bill from Montgomery County. It's House Bill 1402. It establishes the right of non-probationary employees of the Montgomery County State's Attorney's Office, including non-supervisory assistant state's attorneys, to bargain collectively in accordance with the laws that govern collective bargaining in the county. We have a letter of support from the county senators.
Okay, all in favor of local bill, House Bill 1402? Come on, it's a local bill. Okay, you got it.
You guys vote for those all the time. Yeah.
Okay, now we have two withdrawals. I think that we can do together. There's only two on this list. Okay, can I have a motion unfavorable for withdrawal of Senate Bill 690 and Senate Bill 1064?
Move
Senate-
unfavorable.
Senator Ellis beat you to it, Senator Mount second. All in favor of the unfavorable on 690 and 1064? Unanimous vote. Thank you. All right, what's next?
Job, David.
Next
Patrick,
is,
welcome back. We missed
Thank
you.
you. It's great to be back. The next bill on the list is House Bill 36. This is a bill that had been held from a previous voting session. And it's the Insurance Administration's departmental bill that relates to public adjusters and establishing certain limitations on solicitation and other consumer protections. So just to review, there was with the House bill struck a limitation on solicitation within 24 hours after the loss or damage is covered by after the loss has occurred. You'll recall that the Senate had adopted a limitation on solicitation during the loss producing event, like while the flood or the fire was going on. So the House struck that limitation on solicitation, but what they did was they increased the right to rescind the contract to 15 business days after the date that the contract was signed. So under the both bills as introduced, it's 3, let me see. It's 3 if the individual was under the age of 65, or 7 days if the insured is at least 65 years or older. So they pushed that right to rescind the contract back to 15 days. And then one additional change was there was a notice requirement that a public adjuster has to notify the insurance administration within 72 hours of entering a contract. And hold on one second. And so they have to provide, you have to provide this notice that they've entered into a contract to the insurance commissioner within 24 hours after the public adjuster enters into the contract. And the House bill changed that, so they have to provide that within 1 business day. So instead of 24 hours within the date that the contract was entered, it's 1 business day. So I think where things stand, the point of, the issue is the length of the right to rescind a contract. That 15 days was increased as a counterbalance to striking that limitation on solicitation during the loss producing event.
I've heard from some proponents that 15 days is longer than any other state in the country. Some states have 10 days. And so I'd like to propose that if we can do a verbal amendment, changing the 15 days to 10 calendar days,
Business days.
10 business days. So can we agree to amend it to 10 business days, point to receipt? Do I have you're shaking your head, Senator, your motion for 10 days? Second, Senator Klausmeyer. All in favor of 10 business days? Thank you. Can I have a motion for the amended bill, House Bill 36? This is the public adjusters. That's how we refer to it. And Senator Ellis, second. All in favor of House Bill 36 as amended? Thank you.
Okay, the next bill is House Bill 250. This was a bill that we had heard or we had at a voting session previously, and it was held for possible consideration of an amendment. This is the departmental bill of the Office of Financial Regulation. It authorizes the Office of Financial Regulation to examine a third-party service provider as to services and activities performed on behalf of an entity licensed or chartered by the office. And so the committee had already adopted some amendments that were requested by the Maryland Bankers Association. And so now the question is whether the committee moves the bill as amended.
Is it in the same posture now as the Senate bill?
So these clarifying amendments that were requested does put the bill in a different place. But this was something that the Office of Financial Regulation worked out with the Maryland Bankers.
So the House will amend the Senate bill, hopefully, to look like what we do today.
Right.
Senator Hershey?
Yeah, thank you, Madam Chair. This is the one I was trying to get that amendment that was going to carve out some of the smaller businesses. I did send it to Department of Labor. They had some concern about it. Can I take one more day to figure that out with them?
One more day will be Tuesday. We're starting to get.
Okay.
Anything we pass Tuesday, I was barely going to get out. But if you want to hold it till Tuesday, we can do that.
Yes, thank you very much.
All right, thank you. All right, House Bill 896.
So House Bill 622. This is a bill that prohibits a consumer reporting agency from including in a consumer report any record of a criminal proceeding concerning the consumer in which the consumer was falsely accused acquitted or exonerated, in which a no pros was entered to a charge concerning the consumer, or that did not result in a guilty verdict for or guilty plea by the consumer. A consumer reporting agency then is also prohibited from including in any criminal records containing the consumer that have been expunged. A consumer reporting agency can't rely on the information contained in these records when making a determination regarding the creditworthiness of a consumer.
Any amendments?
No amendments.
Can I have a motion for House Bill 622? Are we paying attention?
Move favorable.
So I don't have a second. There's no second? You know what this is saying? If somebody was charged but not found guilty, they wouldn't be part of their credit report. They were charged but not found guilty, right? No pros or
Correct.
whatever. Okay,
Falsely accused, acquitted, exonerated, if a no pros was entered, if the charge did not result in a guilty verdict or a guilty plea by the consumer, can't be included in the consumer report.
so I have Senator Klossmeyer and Senator Ellis. You have a question, Senator Reed?
Yeah, just one question. Does this include even if they were like not found guilty? I don't have a problem with, but does it includes like, does it include PBJ? I'm thinking more for like financial issues, and I don't really care if they were, found PBJ for some like fist fight outside a bar. It didn't matter their credit, but what does this deal with?
Yeah, I don't think it would include a PBJ.
PBJ, you're still found guilty, but you're
Right.
not.
So
but
this
you're
is
not-
where someone say again? Right. Right, it's not a guilty finding. So it would not include any record in which the consumer was falsely accused, acquitted, or exonerated, in which a no pros was entered, and did not result in a guilty verdict.
No
for a
pros could
guilty
also
plea.
be, I'm sorry, I apologize.
Go
I
ahead.
interrupted you.
No,
A no pros could also be a state's attorney declined to bring charges.
To bring charges, correct.
Yeah, I mean, I get the logic. I'm like, if somebody's like, I guess in financial crimes, you wouldn't have a whole lot of times that there was a null pros unless there really wasn't anything there, probably. I don't know. That was my one hang up, but
okay.
All right.
So we have a motion and a second favorable. Let's take a vote. Let's do a roll call, Madam Chair.
House Bill 622 favorable. Vice Chair Klausmeyer.
Yes.
Yes, Senator Kramer.
Yes.
Yes, Senator Hayes.
Yes.
Yes, Senator Reedy.
It wouldn't be included.
just to explain my vote, I get the rationale of why you say, obviously, if somebody's found not guilty, but we do a lot of stuff every year in the session. We've got people coming in trying to mess with credit reports, and I just don't know. So I'm going to vote no. That's one vote no. I'm just not quite sure about the impact of this.
Senator Ellis.
Yes.
Yes, Senator Mouts. Yes, Senator Guile.
Yes.
Yes, Senator Lamb. Yes, Senator Hershey.
Yeah.
Yes, Madam Chair.
Yes.
Yes. 9-1.
Go woes.
House Bill 89,
So House Bill 896 is the bill that establishes certain consumer protections relating to gift cards. What the House did is they yeah, they would allow the sale of certain gift cards that didn't completely conceal some of the numbers on the cards, if it was deemed to be as protective. And so what Senator Kramer is offering here are amendments that generally make the bill align with the Senate bill, but there are a couple additional clarifying amendments that the Senator is offering, and I will just highlight them. And so in the reprint, you can see on page 5 that this additional exception is being struck, that the House adopted. And then there is a a clarifying amendment relating to open loop gift cards. And that is,
I think it was closed.
I'm sorry, closed loop gift cards. Thank you. And I need to find that on the page.
That's on page 10.
Okay. So that clarification is on page 10, so that we're referring to a closed loop gift card, that the gift card is presented in packaging or includes a special covering that conceals or covers these identifying numbers. And then there is a clarification to the warning that the Consumer Protection Division has to provide, and that is included on page 8. So if you look on page 8 of the reprint, you'll see that the division, before initiating an enforcement action for a violation, has to issue a notice of violation to the alleged violator if the division determines that a cure is possible, if no consumer has suffered damages as a result of the violation, and the alleged violator has not previously violated the subtitle. The division.
On the amendments and on the bill is amended, Madam Chair.
Thank you. Second.
So we, Senator Glassmeyer seconded. All in favor of the amended bill on gift cards? Unanimous vote. Thank you.
House Bill 932 is the prior authorization bill. So there's been generally the bills were in the same posture, except for one difference relating to the protections relating to when you have to allow someone to be able to stay on the same prescription drug. And so there had been some concern about how broad the scope of the protection was that went on the Senate bill relating to the biologic products for the treatment of an immune disorder. And so that has been narrowed through some discussions. The amendment offered here, which the House, as I understand it, is inclined to accept as well, and that's being offered by the sponsor, would apply that protection relating to reauthorization to when a prescription drug is an immune globulin as defined under certain federal regulations, which are drugs to treat certain infections, and when used for the treatment of a mental disorder, which was in the bill originally passed over. So the change is this immune globulin category of drug, and so that's what the sponsor is offering.
Thank you.
Actually,
Senator.
there's one other thing. I'm sorry. In addition, there was an exception to this provision for requested by Kaiser in the bill as introduced, so that they would be exempt from these requirements with respect to a group model HMO, and that exemption is being struck. And from what I understand, Kaiser has been able to review the scope of the bill, and they seem to be fine, with being included now.
Say I did talk to Allison Taylor, and she did agree that they're fine with the exemption. So our vice chair worked really, really hard on this bill. It's been going on all session. I'm delighted we've gotten it to this point. We would love to have had a clear pre-auth issue, but we couldn't. But we got the two important bills, behavioral health and immunology, the bio bills. So anyway, if I can have a motion favorable for the amended bill 932.
Move favorable.
Okay, Senator Reedy and Senator.
All in favor of the amended bill 932.
It's a unanimous vote. Thank you.
I would like to say thank you to Patrick, because he's been right there every step of the way, and there were lots of steps, so, and it wasn't even step therapy, so.
House Bill 996. This bill renames the Consumer Council in the Division of Consumer Protection in the Office of the Attorney General to the Consumer Protection Commission. Was this at the request of the Attorney General? I think it was, yes, I think this is not a bill by request, but they support the change. I think it's the folks on the council who requested the name change.
Is there a fiscal note for what this is going to cost for an increase?
There's no fiscal note.
Okay,
A couple $100,000.
so the Consumer Protection Agency would become the Consumer Council?
The Consumer Council within the Consumer Protection
Okay.
Division would have a name change.
Okay, thank you. Motion favorable for House Bill 996.
Move favorable.
And second, Senator Washington, second. All in favor of House Bill 996? All right, let's call the roll.
House Bill 996 favorable, Vice Chair Klausmeier.
Yep.
Yes, Senator Kramer.
Yes.
Yes, Senator Hayes.
Yes.
Yes, Senator Reedy.
No.
No, Senator Ellis. Yes, Senator Mounts.
No.
No, Senator Washington.
Yes.
Yes, Senator Guile.
Yes.
Yes, Senator Lamb. Yes, Senator Hershey.
No.
No, Madam Chair.
Yes,
Yes, 8-3.
Consumer protection bills here.
I know.
All right, House Bill 1182. This is the bill that relates to the Maryland Antitrust Act and their enforcement remedies. And what the bill does is it specifies that disgorgement is a type of restitution available under the civil enforcement provisions under the Maryland Antitrust Act. Disgorgement is an equitable remedy that says that you have to give back any profits that you gained because of the misconduct. So but for the misconduct, you would not have gotten these profits. So any profits that you got that you derived from your misconduct would have to be disgorged. That's the equity. So that is a remedy that's available under other statutes. But I think that the Court of Appeals, the Maryland Supreme Court had ruled that unless that is specifically referenced as an available equitable remedy, it's not available. And so this is working to clarify that under the Antitrust Act, that remedy is available as one of the tools for enforcement. So I think it would be given back to the party that's harmed. From the anti-competitive business practice.
I'm looking here at the Maryland Bankers Association opposition to this bill. And their opposition is, this is from the House. I don't know if there's been amendments to address their concerns, but if a court were to determine that someone violated the Maryland Antitrust Act, section 11-209 of the commercial law article, provides the court with the ability to enter a judgment to remove the effects and prevent the continuation of whatever the violation happens to be. The judgment can include injunction, restitution, divestiture, and suspension. In addition, a court can assess a daily fine of $10,000 for the duration of the violation that happened, as each day constitutes a separate violation. And they're against the bill because they say the role of the court in antitrust cases is to make the victims of an antitrust violation whole. And the penalties in section 11-209 give a court a wide variety of tools to do that and establish penalties against violators. And this disgorgement, adding it, provides no benefit to the victim of a violation. Instead, adds yet another fine to someone who's already subject to a fine of millions of dollars. So am I correct in saying that this would be a fine that would go to the state and not to the victim, this disgorgement? Or I'm just trying to understand the nature of their opposition.
I understand. So I'd have to resort to look to the testimony here of the Antitrust Division.
Do you mind if I hold it? Yes, thank you, Madam Chair.
Comment would be most appreciative. For the record, he can be talking about it.
Good catch.
Yep.
Patrick.
Yeah.
Just a minute. Be an example of that.
Antitrust.
Yeah, I mean,
Yeah, I mean, so I think these are cases where it's alleged that a business is through monopolistic activity has engaged in anti-competitive practices against competitors.
Okay,
And so,
okay.
so the question is when you have this disgorgement remedy, you know, are those penalties available to the folks who've been harmed, or is that something that's collected by the Attorney General's office? And,
Okay.
you know, I guess that's the point of clarification.
We already asked to hold the bill, so we'll come back to it on Tuesday. House Bill 1199.
House Bill 1199 is similar to the Senate bill that passed 891. This is the bill that requires the Maryland Transportation Institute at the University of Maryland to conduct a study to identify methods to improve the Maryland Transit Administration's Americans with Disabilities Act Mobility Link paratransit service. The House bill is just different in one respect. I think they pushed back the sunset for the study so that it sunsets after the session, which is actually typically what we do. So there's one technical difference, and then the chair is offering an amendment that would strike an item that was added by the House that would require MDOT to incorporate the findings and recommendations of the study in the 2050 Maryland Transportation Plan. So based on some feedback from the Department of Transportation, that doesn't really make sense because that plan has already been printed. So adding it into that report doesn't really work according to their feedback. So the amendment would strike the requirement that it be included in that 2050 plan.
Thank you, Senator. Do I have a second?
Second.
Thank you, Senator Glassmeyer. On House Bill 1199, all in favor? Unanimous vote. Thank you.
House Bill 1299. This is the bill that alters the applicability of the Maryland Consumer Protection Act to include certain unfair, abusive, or deceptive trade practices in trade or commerce, in addition to any economic activity within the state that involves or relates to any commodity or service. And then the bill makes some related clarifying and conforming and technical changes. So under the bill, and if you recall that the testimonies, this would enable, you know, the Consumer Protection Division to investigate and bring actions if you have certain disputes between a business and a business. Whereas right now the Consumer Protection Act is really limited to consumers and goods and services that are primarily for household use. That's the framework.
Second. I second.
It's moved unfavorable. Senator Hershey seconded. Let's vote on the unfavorable.
House Bill 1299, unfavorable. Vice Chair Klausmeyer.
Yep.
Yes. Senator Kramer.
On unfavorable,
Mhm.
Unfavorable.
no.
No. Senator Hayes.
Yes.
Yes. Senator Reedy.
Yes.
Yes. Senator Ellis.
Yes.
Yes. Senator Mouse.
Yes.
Yes. Senator Washington. Excuse me.
Yes.
Yes.
Yes. Senator Guile.
Killer.
You'll be Irish last night.
All right, yes.
Yes. Senator Lamb.
No.
No. Senator Hershey.
Yes.
Yes. Madam Chair.
No.
No.
I
Eight.
don't think Senator Guile will be celebrating St. Patrick's Day in that.
8-3.
That was a 7-3 vote.
8.
8-3 unfavorable.
So House Bill 1333, this is a bill that requires the Maryland Commission on Health Equity, using a health equity framework, to develop and monitor a statewide health equity plan as required by the Center for Medicare and Medicaid Innovation under any agreement entered into between the state and the Centers for Medicare and Medicaid Services, or CMS. This commission must coordinate with the Department of Health and the Health Services Cost Review Commission when establishing an advisory committee. The bill repeals the requirement that the governor designate the commission chair, and instead the Secretary of Health and Executive Director of the HSCRC must co-chair the commission. The bill also expands the purpose of the commission and alters its duties and membership. The bill also alters reporting requirements for and extends the termination date of the Commission on Public Health. So there was no opposition to the bill and there are no amendments being offered.
Senator Hayes was favorable. Senator Glassmeyer moves second. All in favor of House Bill 1333. Can we have a unanimous vote? Thank you. Unanimous vote.
House Bill 1337 relates to health insurance appeals and grievance process and reporting requirements. What the bill does is it expands the required contents for a quarterly report that each carrier has to submit to the insurance commissioner regarding appeals and grievances. Each carrier has to include in the report the number of members entitled to healthcare benefits under a policy plan or certificate issued or delivered in the state by the carrier, and the number of clean claims for reimbursement processed by the carrier. There are no amendments. There's no opposition to this one.
Amendments, no opposition. Can I have a favorable motion on 1337? Senator Washington was favorable. Senator Ellis was second. All in favor of House Bill 1337? Unanimous vote. Thank you.
And then House Bill 1521, this is a health department departmental bill. It repeals the requirement that the Maryland Children's Health Program be administered in a certain way. Specifically, the bill eliminates the MCHIP premium plan and the requirements that families with income above a certain percentage of the federal poverty guidelines pay a family contribution for the coverage. So that right now under that program, there was a small premium that would be collected. It was pretty nominal, but the health department hadn't been collecting that under some federal requirements, and then decided that it was not really actually not cost beneficial to continue to collect it. And apparently there was just yesterday announced a final rule that states cannot collect this premium anymore. So the bill would implement what appears to be required by the feds.
So, Patrick, do we need the bill to coordinate with the federal government? We
Yeah,
still
we
need
do
to
need
do
the
it.
bill,
Okay.
yeah.
So can I have a motion favorable on 1521? Senator Glassmeyer, do I second? Senator Washington, all in favor of House Bill 1521? Thank you. Unanimous vote. All in favor of the unfavorable.
Right. Next bill on the list is House Bill 576, which is an administration bill that authorizes a county to establish an assisted outpatient treatment program and alternatively requires the Department of Health to establish an AOT program in a county that does not elect to establish a program. The director of certain mental health programs or any individual who is at least 18 and has a legitimate interest in the welfare of the respondent may petition a circuit court for assisted outpatient treatment. A respondent is entitled to representation, including representation by the Office of the Public Defender if they are qualified at all stages of the proceedings. If the court finds by clear and convincing evidence that the respondent meets the criteria for AOT, the court must order the respondent to comply with AOT for up to 1 year. The Behavioral Health Administration is required to submit a certain annual report on each AOT program, and the bill generally takes effect July 1, 2025. There are a variety of amendments to the bill offered by the chair, Senator Lamb, and the Department of Health, and I'm going to walk through the reprint that you have before you. Procedurally, the committee could choose to take up the amendments in groups, such as the amendments offered by the chair and the Department of Health, followed by amendments offered by the chair, followed by amendments offered by Senator Lamb, but we can address that after going through the reprint.
Nathan, the way that we're going through the reprint, are all of those amendments already incorporated in here?
So the amendments are incorporated and they're delineated by
labeled.
who is offering them. There are a couple of amendments that are on the back. So for example, Senator Lamb makes amendments to a provision that the chair and the Department of Health are also suggesting an amendment for. So
Mhm.
Senator Lamb's amendment is shown at the back. That's labeled alternate page 15. There's also another amendment from Senator Lamb at the back that relates to mandated insurance coverage and Medicaid coverage, and that's also reproduced in its entirety separate at the back. But as we page through, I will say who is offering which amendment.
Excellent. Thank you. Thank you, Madam Chair.
Nathan, can we assume as we're going through the reprint, these have all been accepted by the Department of Health? All the amendments?
No.
No.
That is not the case, and
Okay.
I've delineated where that's the case.
Okay, thank you.
So the first amendment you'll find on page 4 of 19, this is offered by the chair. It is removing provisions related to psychiatric nurse practitioners conducting certain emergency evaluations. So this amendment would limit the scope of the bill to assisted outpatient treatment programs only and remove the provisions related to emergency evaluation. The Department of Health takes no position on this amendment. I think Senator Hayes has a question.
Madam Chair, is it also fair to assume that the amendments offered by the chair are similar to the House and or have no opposition?
So I can address that.
Nathan can address that.
So these are amendments that are being offered on the House bill. So they were not offered in the House. The Senate bill is next on the voting list. And my suggestion would be that the committee consider moving to conform the Senate bill to the House bill as you pass it after this situation. The Finance Committee waited for the product of the House and Government Operations Committee. The reason for that was that HGO passed an AOT bill in the week before sine die last year. And so the way that it was just easiest to proceed, knowing the differences between the committees and HGO's past position relative to the bill as introduced, to let HGO go first and then proceed this way. So whether the amendments will be all entirely considered favorably in the House, I can't say. I suspect that the ones that are sort of offered by the chair and the Department of Health are probably very likely. And then, from there, it would depend on basically the severity of the change.
Absolutely. Thank you for that explanation. Thank you, Madam Chair.
So we recovered the change on page 4, striking psychiatric nurse practitioners. Moving ahead on page 6, I wanted to highlight this House amendment at the bottom in subsection E that it narrows the definition of harm to the individual, limiting it to self-harming behavior or an attempt at suicide. You can also see on page 7 of 19, the House changed to the definition of serious and persistent mental illness, where now that is a mental illness that is severe in degree and persistent in duration, among some other requirements. At the bottom of page 7, you can see an amendment that's offered by the chair and the Department of Health that provides additional protections to the respondent in an AOT petition. So in this instance, it says that the issuance of an AOT order against a respondent made under the subtitle may not be the basis for the involuntary admission of the respondent to a facility or be used as evidence of incompetency. And further, the subtitle may not be construed to abridge or modify any civil right of the respondent, including any civil service ranking or appointment, the right to apply for voluntary admission to facility, any right relating to a license, permit, certification, or privilege or benefit under the law. This provision mirrors very closely language in the Estates and Trusts article related to, I believe it's petitions for an individual with a disability. Senator Reedy has a question.
Ask a question on those amendment. Thank you. So 2 things. One is I assume this amendment will help with some of the concerns about how an involuntary admission obviously can be used and have sort of what we would call on the criminal side collateral consequences, right? So we're trying to remove collateral consequences. So when it talks about number 2 there, under the new, what would be the new subsection B, the right to apply for voluntary admission to a facility under 10-609. I assume is that some sort of mental health treatment facility, but
Yes.
that had you, but it's not going to be used against you. What would happen right now? Is there a concern that would be evidence that you were dangerous? I guess the concern would be you don't want that to be used as evidence you were dangerous.
So the Estates and Trusts article includes a similar provision related to an individual with a disability to apply for voluntary admission. So I think that it was brought over directly as a reflection of that provision in the Estates and Trusts article. But I would say that the effect of it is that under current law, an individual may voluntarily enter a mental health facility, and this is clarifying that being the subject of an AOT order would not affect that.
Good. Okay.
existence under
This,
current-
I think this is good because this amendment will help deal with some of the concerns that we'd heard from some of the groups about this. So this is good. Okay. Thank you.
Senator, my concern was people that wanted to help themselves, that voluntarily wanted to be admitted, I didn't want that to be held against them. So that was why
That's
we,
also addressed in a subsequent amendment that we'll get to momentarily. Moving along to page 8, wanted to highlight here subsection C, where the House is allowing the Department of Health to run programs in counties that do not elect to establish one. So as introduced, the bill would have required a county to establish an AOT program and allowed them to sort of group together. But now under the bill as amended in the House, the county may elect to not establish a program and the Department of Health will step in. Moving along on page 8, page 10 of 19.
so you're like, okay,
Was not.
okay.
So that provision, so the health department is a state agency
Yes.
in each county. And so each county, if they choose to opt in, would go through the health department of the county.
I think the
So-
distinction here is between the local health department and the department, which under this provision refers to the Department of Health, the Maryland Department of Health. And so it is conceive of it this way, that there could be a local county-based program, or it could be handled at MDH Central, for lack of a better word.
But the local county-based program would go through the county's health department, which is a
The
state
bill doesn't
agency.
prescribe specifically, let's see, an assisted outpatient treatment program established under subsection A, so that would be by a county, shall be approved and overseen by the county's local behavioral health authority or core service agency. So that's how it would be managed in the counties that elect to establish their own program.
All right, thanks.
So then ahead on page 10, this is in line 8. This is another provision. The House had amended the bill to say that a respondent is one of the criteria. So a court may order a respondent to receive assisted outpatient treatment on clear and convincing evidence that, among other things, the respondent has demonstrated a lack of adherence with treatment for a serious and persistent mental illness that has at least twice within the 36-month period immediately preceding the filing of the petition been a significant factor in necessitating inpatient admission to a psychiatric hospital. The amendments that are offered by the chair here and the Department of Health clarify that the admission needs to have been involuntary. And so as the chair was saying with respect to the previous provision, if an individual is voluntarily seeking admission to a facility, then the objective would be to not penalize that voluntary seeking of treatment if then a petition for assisted outpatient treatment were offered. So then Senator Guile has a question.
What was the logic for striking psychiatric on that?
Because I believe my understanding was that there could be circumstances in which there was an involuntary inpatient admission to another facility, another hospital facility that accommodated psychiatric patients, but that was not a psychiatric hospital.
Okay, thank you. Thank you, Nathan.
Moving ahead to page 11 of 19, this is the First Amendment that's offered by Senator Lamb, and it provides 11 of 19. And so this is a provision that would limit the types of things that may be ordered under a treatment plan. And so specifically, it says that with some exceptions, a treatment plan may include medication only if it is approved by the FDA to treat a disorder or condition defined in the most recent edition of the American Psychiatric Association's Diagnostic and Statistical Manual of Mental Disorders. That a treatment plan may include any medication used to treat medication-induced movement disorder. And then subject to the next paragraph, a treatment plan may not include a medical device or procedure, including an injectable device or electroconvulsive therapy. A treatment plan may not discontinue a medication or device prescribed by a licensed medical provider.
I have a question. I'm not gonna know the medical term, but electroconvulsive therapy, is that electric shock therapy? And so
Yes.
you're not gonna allow that? Does this amendment prohibit that?
Yeah, so I think because this is new and, I think the thought was to at least put some outer boundaries of what those limits might be in terms of what people could do, which is medication kind of therapy, which makes sense. But to not let it be kind of the whole panoply of things that this would be opened up to, at least initially. That since this is new, to be able to put some outer bounds of this. We did ask the Attorney General what those outer bounds are. If it's, without this, are there any outer bounds? And it doesn't seem like there are. So, the limitations here are to say, yes, like electric shock therapy, putting outer bounds to say these should be psychiatric drugs. So you can't compel someone to, for example, take birth control because you feel like they have a mental illness and shouldn't be procreating and all that kind of stuff. This is intended to put some boundaries here.
Well, and Senator, I appreciate most of this, but I do have an issue with with you eliminating the electroconvulsive therapy, because I know in many instances electric shock helps. I've known a lot of people that have said it's helped immensely. So I can't support that part of the amendment. I can't. That's my opinion, but.
Senator Hayes.
Thank you, Nate. So would this take away kind of the discretion of the coordinated care team and basing it off of what to the chair's point, there may be cases where electric shock is needed or something else, and limited it only to things that FDA have approved. Don't you kind of take away the discretion of the folks that are providing care to that individual based off of what that expert team deemed to be necessary for that patient?
All of it. This whole area. Yeah.
You want me to?
You or Nathan, either
Sure.
one.
I'm sorry, I was.
Yeah, I distracted Nathan, so
I'm sorry, I didn't know. if this
I
was
thought the
Senator.
question was to Senator Lamb.
he could give it a try.
Go ahead, Senator Lamb.
Yeah, I mean, like I said, the thought is that since this is a new practice and we're giving them new authorities to be able to do this, that there should be some limitations put in place to say that this would be for FDA approved medications and therapies, as well as things that are recognized by the American Psychiatric Association to be used for people that have these conditions. Understand there's some concern about electroconvulsive therapy.
Are there other
you know,
examples of that?
other examples of
Say like, I guess the electric compulsive therapy isn't one of those things that's approved by FDA. Are there other examples of treatments that may not be approved by the FDA that you would be prohibiting with this amendment?
Yeah, I just gave an example. Like if somebody says that if the court orders someone to take birth control because they feel like they have a mental illness and shouldn't be procreating, this would not allow.
No, I'm talking about in this case that I don't see the court in the case of a psychiatric kind of situation, that birth control wouldn't apply in this. And birth control isn't approved by the FDA. I'm learning.
Not for psychiatric illness.
Right. Got you.
Are you finished?
Yeah, I'm done, Madam Chair. That caught me for a loop.
Senator Guile.
Senator Ellis has a question. so let's go there.
Yeah, thank you, Madam Chair. There's a thought and a question. So, historically, some governments have gone overboard with their use of all types of dastardly so-called psychiatric treatment for individuals they deem deficient. And going back to even the history, the Nazis came to study some of these device techniques developed in the United States, and they actually honed some of their techniques based on stuff that's done in our history. I won't go there. And so I think we really do need some guardrails. And I think there is a sunset on this bill, so we could get back and look at it. Is that correct, Nathan? There's a sunset?
Yeah.
I know it's going forward.
No, I'm certainly happy to just explain that because I think that it is an important provision. So on page 19 of 19 and beginning on lines 23, the chair and Senator Lamb are offering an amendment that would sunset the program after 5 years. That's
Yeah.
correct.
Okay, so that's good. I like that. So we could have some guardrails and see how the program works. And then take off certain guardrails, because I think that's a really historically important procedure. And one of my colleagues has said, oh, a court will never do X, Y, Z. Well, in my district in Charles County, a few years ago, a judge ordered a defendant going through a mental crisis in his court to be tased. And the deputy was like, no, I can't do that. And he said, I'm the judge, I'm ordering you to tase that individual. And the individual was tased, stopped his heart. And that judge was brought up on charges and forced off the bench. And its record is on the Maryland Judicial Disabilities website. And so, you know, we cannot say a court will not, because courts, judges are made up of individuals and they have bad days or just bad brains. And so I love the guardrail, and we can come back and look at this and in 5 years with a sunset. So I'd love to support Senator Lamb's amendment.
I'm going to respond to Senator Ellis and then Senator Gollier next. I don't disagree. We need some guardrails, Senator, and thank you for that. And I've known some issues as we talk about like Crownsville and so I absolutely agree, but I don't know that we need this entire amendment that starts eliminating other things that have been approved by the FDA. So part of the amendment's a good guardrail, but I think part of it goes overboard, but we're going to discuss it more. Thank you. Senator Gile.
I just wanted to clarify, because we were just talking about electroconvulsive therapy. It is indeed FDA approved. And Senator Lamb is nodding his head. I mean, I know that there's like maybe a misunderstanding about it, but I mean, to the chair's point, I mean, it's effective. I've seen, patients that have really benefited when they've had no other option. And that's what I'm worried about this too, where I think that it would limit a treating physician or a care coordination team from making certain decisions. I mean, and there's certain instances too where a prescription could be used for off-label type purposes too, right, in the care. I mean, so I just have some concerns about this. So that's all I have to say.
Thank you. Can we go to let's go to Senator Reedy, and then you can respond to everything that's been said. Senator, is that okay? Is that okay? Senator Reedy?
It may be somewhat, so that Senator Lamb may want to respond to both of us. It's a similar line of questioning is, like, are there homeopathic type remedies that a care team could say, we want this to be part of your care plan that are not technically FDA approved? We have a lot of stuff that comes into our committee and other committees about the FDA not moving quickly enough on X or Y. I mean, I think we all agree you generally would want your stuff to be in general practice FDA. I just wonder about putting that amendment into an electroconvulsive therapy. Yeah, I mean, it used to be overused. I think there was an abuse of it a long, long time ago, probably, or maybe abuse is the wrong word, but it was probably overprescribed. I was thinking about Tom Eagleton, you know, the whole Thomas Eagleton thing from 50 years ago, but where there was a stigma about it too, whereas I think now we're not like that. But I don't know. I was going to say, following up on, just wanted to make that point, but also can't in a court proceeding and if you want to answer this question, can't in these court proceedings, can't there be debate about what's appropriate or not? Like if a judge tries to order forced birth control, or something like that, that seems like a real outlier. I would have a feeling there would be an appeals process and there'd be a whole like civil rights question about that would be outside of this bill. So anyway, that's just putting my 2 cents in. I don't know if you want to be that prescriptive in the bill. We're getting a report every year, right? I mean, or as well. No, anyway, I guess I'm kind of piling on, but that'd be my concern.
Senator Hayes, are you part of this discussion?
Yeah, I just wanted to say, I'm empathetic to the concerns that Senator Ellis has raised. Especially, you know, as African American, oftentimes we have been disproportionately targeted. But in this case, when we talk about treatment plans, those treatment plans are in these cases are developed by medical professionals, correct? Not the courts per se. To Senator Reedy's point, if the medical team deemed that it's not in the best interest of their treatment plan, would what interactions does the court versus that medical those medical recommendations has? How does that interplay play itself out?
It's up to you.
To answer part of both your questions, AOT is a way to put some limitations on civil liberties on people, right? And so, yes, a judge could order someone to undergo electroconvulsive therapy. And this is not to say,
despite the recommendation of the medical.
I think the
team.
judge has discretion to issue orders for that individual.
Yeah.
That's the point of AOT, is to have the court be able to either persuade or intervene with that individual that has some kind of psychiatric illness. Now, I'm not saying that electroconvulsive therapy doesn't work, and it is FDA approved, but it is a very extreme measure, right? And it has worked in some instances. I'm just saying that because it is a very extreme measure, has some history there, can we put some limitations on that specifically? The individual can still consent to electroconvulsive therapy if they feel like it helps them. It just takes the ability away from the judge to order electroconvulsive therapy on an individual. The part here about injectable device, the injectable device is like long-acting birth control. So that's the other provision of this. But ECT, you know, yes, is FDA approved. Yes, can be effective for people. But is that boundary a little bit too far for this to be ordered by a judge on someone without their consent? The person can still consent to it if they choose to do so.
Yeah, I think we're just going to disagree on the position of this amendment. I'm wondering if instead of something so restrictive as it being FDA approved and all this other language, we could look at like evidence base, right? Because there, like to Senator Giles' point, there are off-label medications that the treatment team may deem necessary as a part of that treatment plan that would be prohibited if we be able to pass this amendment, but there's evidence that show that type of treatment works for that patient.
You can still use, I think, medications that are off-label because they are FDA approved. So I don't think the FDA approved or the American Psychiatric Association's recommendations are necessarily in question. It's the ECT, the electroconvulsive therapy piece.
That's in
You know, it's not restricting someone from issuing homeopathic therapy either, right? It's not saying that you can't, but the medications that you use, you know, you can use herbal, you can use other things, but the medications should be FDA approved. All medications that are being used off-label are still FDA approved.
Right. And so to your point, the sticking point is the ECT.
It's probably the ECT. Yeah.
Thank you, Madam Chair.
Thank you. Thank you for that. Senator Kosmeyer.
I say, when you have a treatment plan, the doctors and nurses make that treatment plan, and I think they should have available whatever they think is right for that patient. That's all, I think.
I do want to say that I met with the representatives of the health department and they were not fond of this amendment. And thank you, Senator Lamb, for sharing your amendments, but this was not an amendment that they supported. I'll just put that out there.
Moving along. Yep.
I was just asking the
The way that I had proposed it originally was that after getting through all of the amendments that are offered, the committee could take them up in sort of three groups. The first would be amendments offered by the chair and the Department of Health, followed by amendments offered by the chair, followed by amendments offered by Senator Lamb. That's just one option, but that's.
do that. Let's finish going through. It's all right. Thank you. Let's finish going through. Now we're on page 12.
Page 12, at the top of page 12, I wanted to highlight one change that was made by the House that plays into a couple of other amendments downstream. So the House amendments, instead of requiring the care coordination team to consider a mental health advance directive, they must now honor that mental health advance directive that was executed by the respondent. So a little bit lower on starting on lines 11, there's a change here that strikes the petitioner's attorney from being responsible for filing a certain notice with the court. So generally, and this is offered by the chair and the Department of Health. So generally, the chair and MDH amendments on this subject remove references to a petitioner's attorney because there's no requirement for a petitioner to have representation. A petitioner may be any individual over the age of 18 with a legitimate interest in the individual. Senator Washington has a question.
Senator Washington.
Thank you, Madam Chair. I just have a question about the care coordination team. I saw this provision on page 12, but then I went back to see the definition of a care coordination team. Can you just describe to me like what that is and who is considered under this care
Sure. So
coordination team?
on page 6 in line 17,
right.
This is subsection C. Care coordination team means a multiple disciplinary team under the oversight of a local behavioral health authority, core service agency, or the department. And so the particular individuals, it would depend on whether a county has enacted their own program or whether the Department of Health is standing in and enacting the program in that jurisdiction.
So it doesn't underline whom is in that team. It just says it can be the department or some other individuals. That's
the local
assigned.
behavioral health authority or the core service. Yes, but and it may be somewhere else in the bill, and I can search for it specifically. But my understanding of care coordination team is that would it include medical doctors, social workers, other mental health providers, and things of that nature.
And for instance, if it is this group and not just the department, how do they make the decisions based on the individual's care? Is it a vote? Is it how do they make the decisions for that? And then in this provision on page 12, it talks about they shall issue these things or they shall do these things, but who in that group is responsible solely for doing that outside of the department?
Senator Rushing, I think the department is oversight. The care coordination team is the multidisciplinary team with oversight. So the department's not the team.
Yeah, it says, Madam Chair, thank you for that. It says the care coordination team means a multidisciplinary team under the oversight of a local behavioral health authority. So then, I mean, that's even more just not clear of who these folks are that are going to be in this team that's making the decisions for this individual person. So I'm trying to understand who is on that team that's making these decisions and shall submit this information to, the provided folks. So when I saw page 12, I was just trying to understand.
Sure.
Marie Grant, are you here? Did I see you back there?
The department.
Would you, from the Department of Health, will you define for us multidisciplinary team, and if it's in the bill anywhere, tell us where that definition is, please.
Thank you.
Yeah, thank you. Thanks, Madam Chair. So the care coordination team.
Speak into them.
Oh, thanks. So the care coordination team is defined, I think Senator Washington, as you were saying, under page 6 of the bill, line 17 through 19. It has to be under the oversight. In the, I think in another provision, it requires either the county or the department to establish it. So at the end of the day, like if you read it all together, it's a program that is under the oversight of either the county or the department, and it's sort of acting as the county or department. That's why it replaces it there, right? So it's not, the idea is not that it like any group of individuals will get this information. It's like the folks who have been designated by the department or the county who are responsible for working with this individual and working on the treatment plan and welfare, the more appropriate parties to be working on decisions relating to the treatment.
Thank you, but who are these people?
So it is going to be established further.
It's multidisciplinary, but it doesn't say like who these folks are, that we know who they are, the folks to make me feel comfortable that, I mean, any department person can be any individual, correct? So, I mean, I need an understanding of who these folks are and how they make decisions for this person. And if they take a vote for this person, like how does it work?
So when you say take a
Yeah,
vote
because
for
I mean,
this
they make some decisions, and then they would then also have to, on page 12, it says if the respondent voluntarily agrees to this treatment plan, the care coordination team shall do these things. But who on that coordination team says we should, who on that individual said that we should do this? Like is there a chair of that coordination team? Is there a person that shall do these things? Like, who is this team?
The team is going to be an entity that will be, if further details are going to need to be established by the regulation on exactly the requirements for the team. But essentially, they are the person that is working directly with that individual, and they're going to be developing that treatment plan under the programs established by the department.
I understand that the petitioner's attorney, because then an attorney can make the decisions for that person, whomever. Now we're talking about
well,
go ahead. I apologize. I'm just concerned that I don't know who this care coordination team is.
Yeah.
And it's not defined here, and obviously it can change however, but I'm just to say that we're gonna do all these things and then we have this care coordination team. I don't know who these folks are.
Yeah, no, I hear you. So as it is right now, and the reason we offered the change is that the petitioner's attorney, that's the person who so there's no, as I think counsel said earlier, that there is a petitioner, and that can be any person with a legitimate interest or director of a local behavioral health program, files, and they have to attest to all the reasons that they think the person meets all the criteria in the bill. They are not required to have an attorney. But once they make that petition, the whole sort of procedurally, it really becomes more about the care coordination team, the assisted outpatient program, the respondent, who is the person, which the order or the treatment plan is about. And so that was the thought that I hear your concern, but I actually think in this case, petitioner's attorney is even more attenuated at this point.
I saw a care coordination team and I tried to define it and try to figure it out on my own, and I just cannot find what that means other than government
Senator,
officials.
we're gonna hold that question.
Sure, fair enough.
We won't vote on the bill today.
Okay.
We need to work out
Yeah.
some examples of who a care coordination team is.
Yeah.
Making these decisions. So we won't vote the bill today.
Thank you,
but
Madam Chair.
Let's finish going through,
Yep.
okay? We're running out of time. Thank you. Senator Ellis.
Yeah, thank you, Madam Chair. And so following the discussion with Senator Washington was a great pickup. That's really good. I'm thinking about so many veterans who have a unique situation, and most are in the Veterans Administration System. And so we would probably want to, as you work out the care team issue, talk about veterans and maybe put in the Veterans Affairs to bring that in, because every veteran have a long medical file and what they go through. And so I would look for that as you work out the issue with the care team.
Thanks, Senator Ellis. I think that if we're working on tweaking that language, I would think that we can talk about, if clinically appropriate, bringing in folks with
Yes, yes,
expertise
thank
in
you.
that area.
Thank you, Senator. Good catch. Okay, so we're back to page 12.
Yes, at the bottom of page 12, where an amendment that's being offered by the chair in the Department of Health again references the care coordination team, stating that that team shall assist in connecting the respondent to services that would be that would help the respondent to be successful in a treatment plan, including, if needed, things like transportation, housing, and accessibility services. This jigsaws with a provision on the preceding page, page 11, that item 3, around line 23, that says that each service listed in a treatment plan, a community-based provider that has agreed to provide the service to the respondent should be identified. And so it's to clarify some of the discussion around the care coordination team. The care coordination team is not providing the services, they're responsible for developing the plan. I just wanted to make sure that that was
This is when we talk about wraparound services, as it
Yes.
says, could be transportation, could be nutritional services, all those kind of wraparound services.
addressing the health related and social needs of the respondent, correct. So then moving ahead to page 13, this is a provision here that the chair and the Department of Health are offering. It strikes, so the provision says that the court may grant a continuance or postponement of a hearing related to an AOT petition only for good cause shown, and removes a provision about in consideration of the need to provide AOT expeditiously. So it tightens up the rights of the respondent. Down in item 3, so lines 17 and 18, this is another cleanup provision offered by the chair in the Department of Health that says all rules of civil procedure shall apply to cases filed under this subtitle, and it removes to the extent that they do not conflict with the procedures or timeliness required. Moving ahead to page 14, the chair and the Department of Health are striking a provision that says if the respondent has executed a mental health advance directive, then a psychiatrist who's providing certain testimony shall state the consideration given to that advance directive. That provision is no longer necessary because, as amended in the House, the mental health advance directive will be honored. Moving on to page 15, this is a provision related to responses to a motion. And so the bill, as amended, states that subject to another provision, no later than 30 days after receiving a motion and any timely replies to the motion for a material change to the incorporated treatment plan, the court shall issue a response to the motion and any timely replies to the motion. Senator Lamb is offering an alternative to this that is at the back of the packet. It's listed as alternate page 15. And there it provides more guidance with respect to responses to motions, and then also has provisions related to requesting a hearing. And so Senator Lamb's amendments would allow the court to respond to a motion without a hearing, but specifies that a respondent or the party who made the motion may request the hearing. And if the respondent or the party made the motion requests the hearing, the court shall hold a hearing within 30 days. I believe Senator Guile has a question.
Senator Guile.
So Nathan, we talked about this, I think, once before when we were, so the concern that I had was that like a court doesn't, like a response is a response to a motion. Like it could be in the form of an opposition. It could be in, under rules of civil procedure and motions practice, a court doesn't issue a response. The opposing party issues a response to a motion. So
I understand the imprecision of the language. I think that the effect of the provision is that the court will take some action on
To issue a ruling?
perhaps, that would be another word that would, I think that without having to pull out the rules of civil procedure, I can't be more precise in
Mhm.
this session. You know,
Yeah.
the chair has said that there's not going to be a vote on
Okay.
this today, that perhaps we can return to that.
And-
But I think that the effect is that the court would be required to respond in some way, it would to speak, right?
Yeah.
To take action on the requests of the parties, or to make a decision between two options, or
Okay.
something of that nature.
And I mean, for what it's worth, replies are not required under the rules of civil procedure, so there wouldn't be timely, you know?
Yep.
So there's no time parameters to filing a reply because they're not required.
Senator Gall, you want to work on that?
Sure.
And so we'll have it for Tuesday when we vote again.
Okay,
Thanks.
sounds good. Thank you, Madam Chair.
The next change is found on page 16 in line 6. It strikes a reference to the attorneys for the petitioner for the reasons previously discussed. Flipping ahead to page 19 of 19. Item number 4 is an additional reporting requirement that was added by the chair and the Department of Health. It says that the annual report that's submitted by the Behavioral Health Administration must include any information the department has about system-wide impacts of assisted outpatient treatment under the subtitle, including any information from hospitals, local detention centers, and counties. And then in addition to item 4, the chair is offering item 5, which requires information about the costs incurred by the department, the Behavioral Health Administration, and any county that establishes an AOT program, including costs related to attorneys, expert witnesses, and the provision of services provided under AOT orders. And then the last change that is incorporated into the reprint itself is the sunset provision that Senator Ellis was asking about. This is offered by the chair and Senator Lamb. It would terminate the bill after a 5-year period. The last remaining item to discuss is Senator Lamb's amendment, which is immediately following page 19 of 19 here. This provision would require Medicaid and insurance companies to provide coverage of services, drugs, and devices that are ordered as part of an AOT order. And that is everything that for the
Senator
committee
Ellis?
to consider.
Senator Ellis?
Yeah, thank you, Madam Chair. And so deal with the sunset. So we saw with the canvas technical amendments we had, a huge bill to fix a big bill, right? And that's a year after. And this is a potentially very big bill affecting a lot of things, and we never get everything just right. So I'm wondering if, I'm very happy for the sunset, and thank you for that. But I'm wondering if we should really have a shorter period of sunset to really look at this and look at the report, force us to really look at how this program is working in the state to really make sure we get it right.
Senator, we can always come back. There's going to be an annual report.
So, yeah, two
So-
things to that point, that, you know, there is the annual report submitted by the Behavioral Health Administration. So that happens every year. And then also the bill becomes effective on January 1st, 2025. And then the AOT programs are required to start on or before July, I believe it's July 1st of 2026. Now, the programs could begin before that, July 1st, 2026. But there will be some ramp up time. And so the number of years in the sunset provision here is intending to allow for that initial development period, as well as at least a couple of years of data to be collected about the program.
So thank you for that. So the 5-year period runs from when
So the five-year period begins on July 1, 2025, and so the bill would terminate June 30th of 2030. But as the chair was referencing, of course, the legislature could come back at any time, even before the programs begin and make changes
Right.
to it.
Yeah, I understand that.
Because we'll have an annual report.
Yeah.
Correct,
So-
and the General Assembly of its own accord,
Right.
even before the report is brought in, if additional concerns are raised
Yeah.
about provisions of the bill that could be addressed even before the program takes effect.
Yeah, I understand that, and but we have a lot of reports coming to us, a lot of studies, and I mean, whoever really pulled them off and read them. Okay. One hand, Madam Chair. That's why you're Madam Chair, but but a lot of times, you know, from history, they just sit on the shelf someplace and never really. I'm just so concerned about that. I mean, I'm happy for the sunset. That really is great, and
You know, Senator, we all have things we follow carefully, like for me, it was emergency department wait times, and I read every draft and final report. And so if this is your concern, read the report next year.
okay.
I mean, really, you know.
Okay.
We
Thank
we don't all read every report,
Yeah.
but if we have, you know, issues that we focus on, I think that's, you know, where your focus needs to be.
And that's fair. Thank you.
Senator Hayes.
Madam Chair, I guess my question is more of like a procedural question. I understand we're not going to vote on the bill in full today, but it sounds like at least the amendments that you and the department came up with, it doesn't sound like there's any outstanding question on just those. I wonder if we could at least vote on just those. We could have a cleaner version the next time we meet and it's easier to follow. Because I know sometimes for me, it's difficult to go back and forth and those amendments, yada, yada, yada. And at least if we have kind of consensus around what has already been decided on, that we could get through that.
So Senator. Do I hear a motion to favorable on the department amendments?
Yes, ma'am.
Okay. Is that okay?
Well, there's two categories. I just want to be clear. And if you wanted to do
That's just the chairs and the department.
the
Together.
chair and the department, none of just the chair amendments. So for example, got it.
Let's start out with the chair and department amendments.
Okay.
So can I have a motion favorable? I have a motion favorable, a second. Do I have a second? Senator Kramer, on the chair, the ones that the chair and I agree on, favorable. Okay. Okay. Okay.
I did.
I'm sorry, Senator Classmeyer had a question first. Okay, Senator Washington.
Thank you, Madam Chair and Madam Vice Chair for that. I wonder if we accepted the amendment because it does include the changes to the definition for that care team. And if we did accept that, because we're talking about potentially changing that or maybe just delineating that, I wonder if we.
Nathan has a comment.
Sure.
I'm sorry, could you be, are you referring to the change on page 12 in line 11?
You know what, I'm looking at it now. It only says or department, so I think it's clear, but I think in the next, when we do vote this bill, I think we should have a clearer definition of what this care team is, so I think I'm fine.
So
I'm fine.
the way
I'm
that
fine.
I understand the procedure here, thus far, Senator Hayes has moved what I would call consensus amendments of the chair and the department. There may be a motion for the chair's additional amendments, and then there may be a motion for Senator Lamb's amendments, but that when the bill is back before the committee on Tuesday, likely there will be additional amendments, at least one, hopefully addressing the care coordination team definition, and then potentially a second one would be offered by Senator Guile related to the response to motions filed. Is that a fair summary so far of where we are?
So this motion that we're gonna vote on now is, thank you. This motion we're gonna vote on now is for amendments that are approved by MDH and supported by the chair. Okay. So we have a motion favorable, everybody that is in favor of those amendments. Okay, got those out of the way. Thank you. Nathan?
I think now the issue is whether there's a motion before the committee on the chair's amendments, which I can. Okay, sure. The chair's amendments, specific, the ones that are the chair's amendments of the Department of Health is not joining, for lack of a better word, are on page 4, removing the psychiatric nurse practitioners from the bill. The additional.
That's the nurse practitioners from the first evaluation.
which is not related to the AOT
Okay.
program. Yes. The next amendment from the chair that is not related to ones that the Department of Health offered, I believe is on the back of the bill. That would be page 19 of 19, the provision about the report, including information about the costs incurred by the department, the administration, or a county. And then the third one would be the sunset provision that's offered by the chair and Senator Lamb. So there's three elements.
Senator Kramer, motion's favorable on that. Do I have a second? We have a second. Motion and second on those three amendments. All in favor of those three amendments? Unanimous, 10-0. Okay.
Okay, so then the remaining elements are, I believe, two amendments offered by Senator Lamb. The first one.
Page 11, lines 26. Starting at line 26.
Yes, so these are on, as the chair said, on page 11, starting at line 26, these are limits on the order that may be incorporated into an AOT order. And Senator Lamb, if you'd like to summarize again, or I can, or the committee can move.
Go ahead, you can go ahead.
Summarize it for you. Great. So Senator Lamb's provision here again establishes additional limitations on what the treatment plan may include, limiting it to medications only if it is approved by the FDA to treat a disorder or condition defined in the most recent edition of the American Psychiatric Association's Diagnostic and Statistical Manual of Mental Disorders. A treatment plan may include any medication used to treat medication-induced movement disorders, and that, subject to the next paragraph, a treatment plan may not include a medical device or procedure, including an injectable device or electroconvulsive therapy. And then finally, that a treatment plan may not discontinue a medication or device prescribed by a licensed medical provider.
Well, before we do that, I have a question.
Senator Ellis.
Yeah, and so, thank you, Madam Chair. So from the discussion with Dr. Lamb's amendments, I don't think it's very popular, but you did mention, Madam Chair. You did mention, Madam Chair, that you believe in guardrails. So could we amend his amendment to take out that particular treatment, the injectable device or electroconvulsive therapy, and leave the rest in there? Doctor, I don't know what Dr. Lam.
Can
we
we hold this as part of the Tuesday work?
To
And,
consider again on
yeah,
Tuesday.
I'd like to
Certainly.
have some more if you don't mind, I'd like some additional conversations with the
Okay.
Department of Health.
Yeah,
I'll be here all day Monday. You're happy to come work with me.
Okay, yes, ma'am, I will be here.
And then the final issue then is Senator Lamb's amendment that is after page 19 of 19. And this would require Medicaid or insurance companies to provide coverage for the services, drugs, and devices that are ordered under the
Well, who
program.
else would pay for it if Medicaid, Medicare, and commercial insurance didn't pay for it?
The patient
would be stuck paying for it.
if those
So
entities did not provide
So
it.
we would court order and we would have the patient pay for it. Okay.
Right, so this is to ensure that the patient isn't stuck paying for medication or treatment that the court ordered that patient to have.
Okay.
Yes, the information that I think the department provided on this in testimony was that first, many of the respondents are likely to be recipients of Medicaid, but that regardless of whether the individual is a Medicaid recipient or has private insurance, the development of the plan through the care coordination team and the providers that would be part of it would likely be based on medical necessity, which would be the same requirement for coverage of the procedure or service or medication under Medicaid or the insurance plan, to provide some context.
There's no guarantee that whatever the court orders would necessarily be covered by either Medicaid or by the insurance company. They could still be stuck with a large bill under no kind of say on their own because this is a court order treatment. So
There
if
is
we're
no
gonna order,
guarantee.
if we're gonna order treatment on people and including people that may or may not have health insurance or underinsured, we should have this covered so they're not stuck with a bill when they're already under duress mentally.
I have a motion favorable for that amendment. Senator Ellis starts, and we have a second with Senator Kramer, all in favor of the Lamb amendment on payment of services. Okay, I think they are too. Thank you, Senator Lamb. Okay, so we'll revisit this on Tuesday with a couple more amendments. Really, if you have amendments or things you want to offer, please get them ready Monday because Tuesday's probably going to be a big vote day. Okay, thank you. Senator Hayes.
On the amendment that we obviously just passed, it just whew, went past me real quick. Can we get, if the department's listening, can they make sure they give us feedback on
Yes.
what those implications are?
Yes, I'm sure they'll be giving us feedback, Senator.
Thank you, Madam Chair. Appreciate it.
I think Marie Grant and I are going to spend some time together.
Ready to move on to the next? All right, so Senate Bill 453 will be held as well. The next bill is hopefully a bit less controversial. This is House Bill 806, the Physician Assistant Modernization Act of 2024. So speaking very, very broadly, the bill requires a physician assistant or PA to have a collaboration agreement with a physician or group of physicians rather than a delegation agreement with a supervising physician, and authorizes a PA who has notified the Board of Physicians of a collaboration agreement to practice medical acts authorized under a license issued by the board and the PA's collaboration agreement. So among other provisions, a PA may perform additional duties within the scope of the PA's practice as specified. The bill also alters the education and examination requirements for licensure and makes other conforming changes. I will say at this point, there is one very small technical amendment for you to consider that's reflected in the reprint on page 31. It strikes an extraneous may. But beyond that, I'll say that generally this bill is the culmination of a 3-year process, and it reflects the agreement reached among all of the interested parties. So the House amendments make numerous stylistic, technical, and conforming changes, in addition to several substantive changes, which I can very briefly describe. So the
Second, oh, I can't second.
Second. Second.
I just want to mention early, I believe in December, I met with both sides on this issue. This is the 3rd year trying to modernize this. And I gave them both an order that this bill needed to pass this year. And they worked, I did, and they worked really hard together and made a lot of concessions on both sides, both the doctors and the physician assistants. And we didn't make everybody happy. And I think that makes it a good bill. Senator Ellis.
Madam Chair, so this has a Senate crossfire which hasn't moved. So how do we, if we move the House? what do we do with
It's
the-
right here. We're going to move them both.
Oh, I'm sorry.
And that's
I
okay.
had to read ahead.
Thank you. We're going to move them both in the same. So we have a motion and a second. All in favor of modernizing the physician assistants? Thank
with-
you.
With the technical amendment.
With the technical amendment.
Thank you. And then next is Senate Bill 167. The committee could move to conform. So it'd be favorable with amendment
Okay.
on Senate Bill 167.
All right.
All right, House Bill 1497. These are bills that were heard earlier this week. So this one alters the definition of practice massage therapy to include certain techniques. A former licensee seeking to reinstate a license must submit evidence of having completed a certain criminal history records check. And then finally, the State Board of Massage Therapy Examiners must require any applicant whose application to the board is reviewing or a licensee whose license the board is investigating. They may require them to submit to an appropriate examination by a healthcare provider designated and paid for by the board. There are no amendments. There is no fiscal impact. There was no opposition.
We have a favorable from Senator Plassmeyer, second from Senator Gall, all in favor of House Bill 1497. Senator Payne, you with us?
Yes, ma'am.
Unanimous vote.
Next.
When I say unanimous, I'm looking, so thank you.
The next bill and the last on the voting list is House Bill 1498, which prohibits an individual from aiding or abetting the unauthorized practice of massage therapy in the state and establishes related penalties. There are no amendments, no fiscal impact, no opposition.
Favorable. Second. This is the anti-prostitution bill.
Oh, is that what it is?
Like, what?
Are we establishing like a mandatory minimum sentence? Or something? Like, okay, all right. No, I was just wondering, it was just like practicing without a license is now gonna be criminalized, but that's not what this bill does, I take it. Okay, thank you very much. That's all I need to know.
That is a good question. What are the penalties associated with it, Nathan?
Sure, for a first offense, there's a fine not exceeding $5,000 or imprisonment not exceeding 1 year, or for a subsequent offense, a fine not exceeding $20,000 per day, or imprisonment not exceeding 5 years.
Got it. Thanks.
All right, I forgot. We have a motion.
Yes.
You have another question? No. Okay. So Senator Hayes motion. You second, Senator Putnam.
Prostitution.
All in favor? If you've never had a prostitution establishment in your.
All right.
I got a couple. All right, so that ends our voting session for today. I want to thank you all for being attentive and cooperating. And we will see you Tuesday, I guess at 1 o'clock, our regular, right after. We have one bill hearing on Tuesday at 1 o'clock, and we'll finish what bills, hopefully we're going to finish what bills we haven't finished. Thank you.